Hello, our group is going to be talking about insider trading. We are group number 4 from Business Law 550, and our group consists of Candace, Jared, Max, and Allie. We've broken our presentation down into a couple key pieces. We're going to start with an introduction, then talk about key legislation, impactful cases, current legislation, ethical framework, and then wrap up with a conclusion. Insider trading refers to the buying or selling of securities, such as stocks or bonds, by individuals who possess material, non-public information about the security. This information is typically not available to the general public and gives insiders an unfair advantage in trading, as they can make informed investment decisions based on privileged knowledge.
So of course that poses an issue on what's ethical, what's not, what's legal, what should be or shouldn't be allowed. So in order to better understand, we need to talk about some key legislation that's already in place. First, initial, most important piece to insider trading key legislation is the Securities Exchange Act of 1934. The legal framework for regulating securities markets in the United States, and it includes provisions directly and indirectly related to insider trading, aiming to ensure fairness, transparency, and investor protection. It prohibits fraudulent activities in connection with purchasing or selling securities, specifically prohibiting insider trading, requires insiders to report their transactions to the SEC, and Section 14 talks about transparency and fairness in the securities market, which indirectly connects with insider trading and helping to prevent trading abuses. We have the Insider Trading and Securities Fraud Enforcement Act of 1988. Turning point in the history of insider trading regulations in the United States. It served as an amendment to the 1934 Securities Exchange Act and came about after many high-profile cases regarding insider trading to prevent or hold those found guilty to the most severe penalties. The Act provided a definitive framework for what insider trading is and expanded on direct and indirect involvement on insider trading. Times have changed from 1934 to 1988, so we had to make sure that the legal side of things changed as well. It prohibited trading based on non-public information, established the SEC Civil Enforcement Authority, allowing the SEC to seek civil penalties, established the concept of disgorgement or returning the profits gained illegally. The Act also established a minimum prison sentence of 3 years if you're found guilty and a fine of up to $5 million for individuals and $25 million for corporations. And then it established whistleblower protection. Last would be the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. This identified risks in advance. The FSOC worked with the SEC on accounting issues. Hedge funds had to register with the SEC. The SEC whistleblower program was created, offering rewards and protection against retaliation, and transparency in financial markets, aiming to promote greater accountability and reduce opportunities for corporate misconduct.
This slide and the next slide are going over some impactful cases related to insider trading. The first scandal that I would like to go over is Ivan Boesky and Michael Milken, as they had one of the biggest insider trading scandals in history. Ivan Boesky and his stock brokerage company were receiving non-public information from Michael Milken, and this information that Milken supplied to Boesky and his company was related to capital and possible corporate takeovers and mergers. Boesky used this information to have takeover bids, and it helped manipulate stocks of those corporations, and it helped both of them in the process. They both made hundreds of millions of dollars. And through this process, it caught up to them as both were later convicted of multiple counts of insider trading. Boesky in 1986 and Michael Milken in 1990, as both had to pay fines and stay a number of years in prison. This big case led to the introduction of stricter regulations and increased scrutiny of the financial markets in this industry. The next impactful case in insider trading that I want to talk about is Goldman Sachs, and this is related to Eugene Plotkin and David Patchson. They were both former employees while working at Goldman Sachs. In this case and scandal, they would both pay a Merrill Lynch employer to help receive tips and non-public information on major mergers and corporate takeovers, kind of related to the last case with Ivan Boesky and Michael Milken. Both of these guys would pay for shares of stock before Adidas and Reebok took their merger, as they received info beforehand. And then they would sell the stocks or the shares of stock after the news broke. And they did this to try and get a quick profit. And they did this multiple times with many different other mergers and non-public information and tips that were given to them. They were both convicted, again, on multiple counts of insider trading in 2010, and they had to pay multiple fines, and they spent multiple years in prison. This scandal brought concern over current regulation over financial markets on insider trading, so that's why it was kind of impactful in that regard.
The following slides analyze how each of the 5 ethical frameworks, free market, utilitarianism, deontology, virtue ethics, and ethics of care, can be applied to insider trading. The free market ethical framework contends that the overriding goal of any business is to be profitable, that managers have a primary responsibility to improve the value of shareholder investment, and free markets achieve the best results without government interference. Consider possible benefits of legal insider trading. For example, insider trading allows non-public information to be reflected in a security stock price, thereby increasing market efficiency. To illustrate this point, if insiders know the company has performed well, they will buy more of the stock to make a profit. The corresponding increase in stock price signals to the market that the company has done well. Conversely, insider trading creates an unfair market in which a select few people trade on material non-public information, which undermines public trust in financial markets. Individuals with access to insider information are able to make money with greater ease than a trader without access to information. As the dependability of the securities market is largely driven by the perception the markets are fair, insider trading must be prevented when applying the free market ethical framework. Utilitarianism is a principle of ethical behavior which contends that the best way to behave in a given situation is to choose the alternative that is likely to produce the greatest overall good. As it relates to insider trading, the utilitarian ethical framework contends that market freedom is only good insofar as it promotes maximum public utility. For example, insider trading may be beneficial to the extent that it benefits the public by increasing market efficiency. However, application of the utilitarian ethical framework would require protections to be enacted that would protect individuals from harm caused by the practice of insider trading. Policies regulating insider trading would be implemented based on the alternative that is most likely to produce the greatest overall good. Deontology is marked by a steadfastness to universal principles, including respect for life, fairness, and telling the truth no matter the consequences. Under the deontological ethical framework, the practice of insider trading would be considered unethical. Under this framework, individuals have a duty to treat everyone with respect, and moral behavior is a matter of holding without exception to certain principles. As insider trading creates an unfair market that benefits only those with access to information and punishes those without access to information, the practice would not be allowed. Rather, deontology promotes a more level playing field for all with respect to financial markets. Virtue ethics directs attention to what human beings are capable of and how they can cultivate good habits of good character. Its focus is on the fundamental character and motivations of the individual. When an individual acts on insider information, they do not consider the negative impact of the investing public and erode trust in financial markets. Virtue ethics requires that one strives to achieve moral excellence. Allowing the practice of insider trading is inconsistent with virtue ethics theory. The final ethical framework is the ethics of care. This framework is grounded in caring for others. The practice of insider trading, where one acts on non-public information, does not consider the implications for others and erodes fairness in financial markets. Ethics of care promotes care and empathy towards others. Acting in a way that is dishonest or creates unfairness for others in the market is inconsistent with the ethics of care. Rather, regulations that promote a level playing field with respect to financial markets would be encouraged.
In conclusion, insider trading connects legal, economic, and ethical considerations in the realm of securities regulations. In our investigation of key legislation, impactful cases, current issues, and how insider trading relates to the ethical frameworks explored in depth in our course, we have found that the practice of insider trading erodes investors' trust and undermines the integrity of the financial market. We live in a time where information is easily accessible and ethical boundaries are crossed every day to get ahead, especially as it relates to finances. It is highly important that society advocates effective regulatory measures, strict enforcement of violations, and a complete commitment to upholding the integrity of the securities market.